Hi everyone, Harry here to talk about some interesting legal skirmishing going on in Georgia involving the Fulton County prosecution, which we've pretty much been treating as comatose, but it's still got a little bit of life and some legal maneuvers that really could matter. I'm going to talk about two, one by Trump and one by Ken Chesebro, who pleaded guilty early on, thinking that he was making a smart move of minimizing his exposure, and now feels unlucky or like a moron for pleading, and now the whole case looking to maybe be going away. Okay, but the context of it is the case is now in the Court of Appeal, not on the trial level, and it's there on appeal. Trump and others appeal from the decision by the trial court not to recuse Fani Willis and her office. He took her to task for the relationship with the prosecutor whom she had appointed to run the case, but said there's no financial conflict of interest, which indeed there isn't, and that's what you would need to recuse her. So he said no, but permitted Trump and others to take the appeal, which they did. But then mysteriously, a few weeks ago, while it's on appeal, the Court of Appeal just issued this Delphic order saying, we're taking this case off calendar, and, don't call us, we'll call you. Basically putting it into deep, deep mothballs, and without any indication of what has to happen to revive it. Not the same as dismissing it. So that happens. You might have seen that at the time as a favorable outcome for Trump, because at least it wasn't any kind of clear and present danger. But he's now looking to basically mop up the field and get all the cases against him just completely swept away. So we have the federal cases where they are dismissed, although without prejudice, and he may still go after that without prejudice aspect because it raises a theoretical possibility that the cases could return after his presidency. We have New York, where there's a whole big fight going on, and he's filed a motion to dismiss, again, to make the whole thing go away, not just to put it on ice during a presidency. And now Georgia. What do you do in Georgia when the court has said, this is off calendar, we're not going to be doing anything with it? And what he has filed is a motion saying, you lack jurisdiction, Court of Appeal, because that permits him to invoke a doctrine that says the court always has to consider challenges to jurisdiction and always can consider challenges to jurisdiction. So this is his preliminary gambit. People haven't noticed this so far. I think this YouTube's the first to do so, but he thinks that that's the way to kind of get them out of hibernation, or get the case out of hibernation and force them to look at it. Of course, that requires him to have a jurisdictional argument. And basically, it is the same argument as for the federal cases. He's saying the OLC memo is figuring in here again, and which of course is not law, applies only to the executive branch of the federal government, hasn't even been adopted by federal courts for the federal system, although the Supreme Court immunity opinion drops a footnote that gives it more kind of heft and credence among federal courts. But he wants to say there is this principle that the OLC memo announces, that you just can't, a court can't do anything with a sitting president. Now, of course, he wants to try to expand that, importantly, in two ways. One, he wants to say that applies to president-elects as well. And second, he wants to say, going back to what we were talking about, that it won't do to hold things in abeyance and just suspend them until the end of his term. Real problem there is the OLC memo says exactly the opposite. It says that you can hold it in abeyance, so he's looking to stretch that one too. And there's a sort of pincer technique on his part, doing it in both New York and Georgia, and hoping it works its way up to the U.S. Supreme Court, which recognizes that principle and says that he, in fact, gets a free pass total not to come back in the future. So there's a pretty short motion in Georgia because it's styled as a challenge to jurisdiction. It's not like New York, which was a whole screed challenging all kinds of evidence in the trial and then ending up with a big principle of New York law and the OLC memo and the Inauguration Act. This is just, guys, you've got a jurisdictional issue, and that is you can't exercise jurisdiction over a president-elect. So that's, that's an extension. What the OLC memo says is you can't bring it. It's not the same as saying there's no jurisdiction, which would mean, there's not even any ability to consider the claim in the first place. But that's the sort of shoot the moon approach that Trump is taking here to say just you've got to dismiss it and now and forever, and citing this jurisdictional question. So it puts the Court of Appeal, it pushed back kind of firmly on the Court of Appeal's obvious decision to put things in deep freeze and maybe forever, because Trump wants more. He wants the thing to go away. And so he's making this jurisdictional argument. Now, it's going to be hard, I think, for them to be completely silent. They could say, no, we still have jurisdiction. And by the way, in his jurisdictional argument, he's making not just OLC, but he is bolstering it by saying the Supremacy Clause and principles of federalism mean that all of this applies to a state court as well. In some ways, even more. You can't disable the sitting president. Again, that's a new principle. And again, that principle could be true without it being a jurisdictional principle, keeping them from even hearing it. But that's what he's trying to get the court to say, and at least try to dislodge them from their silence and get them talking in a way that he can then try to manipulate them into what he really wants, which is to make the whole thing go away here and now and forever. Whereas what he seems to have is it being in deep freeze. Okay, let me just return now to Ken Chesebro, who had come in early, realized the writing was on the wall, and decided he better plead guilty, and got a very sweetheart deal from Fulton County at the time. And the writing was on the wall, but all of a sudden the wall is demolished and they're in a different building. And he's like, no, now I've pleaded to the charge. Now he gets a pretty light sentence, 5 years of probation. At the end of it, certain things could go away, might be able to practice law. But of course, now he wants the whole thing to go away. And here is his gambit. It actually is also related to jurisdiction. The claim to which he pleaded guilty was one of the 3 counts that Judge Scott McBurney later dismissed on motion of Trump. It had to do with filing false materials in court saying, we have this electors' certificates, and that was just a lie and a fraudulent scheme as part and parcel of trying to steal the election from Biden. But, said Judge McBurney, you can't bring that here because the state doesn't have the power to prosecute a fraud submitted in a federal court. That's got to be the federal court's lookout. And that, in fact, is what happened here. It was filed in a federal court. So now there's a whole doctrine. I mean, he's pleaded guilty. And I think maybe the appeal isn't even left, but there's a doctrine that gives sort of narrow review and relief when you've pleaded guilty or been convicted of something that a court subsequently determines isn't even a crime. It's a complicated area having to do with retroactivity, but that's what Chesbro is trying to say. Look, I pleaded, it's not even a crime, so it's a due process violation. You've got to scrap this charge from the books and let me as well be a free man, notwithstanding my decision before to plead guilty. So that's going to be an interesting motion too, that has to do with really basic principles of jurisdiction. He's trying to say not just this was a mistake, but rather it was the kind of fundamental mistake that actually made non-criminal behavior into a crime, and therefore provides a broader avenue of relief, including here, he argues, to make the whole plea just go away and return him to a clean slate and let him, as Trump is trying to do, just kind of pretend it all never happened. So that's the efforts going down in Fulton County, where, remember, the case is in the Court of Appeal that seems to have no disposition to do anything with it, but two different ways to try to force its hand. Trump saying, you've got a jurisdictional problem because you can't do this to me. Is that a jurisdictional problem? Well, that's what we'll see unless the Court of Appeal holds to its silence. And Chesbro is saying to them, I've been convicted on a plea, it's true, but convicted of conduct that isn't a crime, and I have a right to get out of that conviction. So that's potentially a lot of action and nuanced law and federal constitutional law, and we'll see how the Court of Appeal, which until a few days ago thought it was effectively done with this case, as far as anyone could tell from its order saying this is off calendar, now may be pressed into service, and we'll see how they handle these two fairly fundamental arguments from Trump and Chesbro. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.